Hello, everyone. Glad to see you back again. We're going to give it a couple of more minutes to see if any more brave souls come back. They're not out doing their Christmas shopping, that they're going to continue to learn and educate themselves. But I'm very, very glad you guys are here. Want to make sure that you know that we are recording again for tonight for educational purposes. Glad to see that you guys are here.
Awesome.
Thanks, Peggy.
She must have a TikTok clock or something, or in the
I
car.
heard it too. That was great sounding. Either that or a metronome, and she's a piano player. Mary's got some pretty Christmas lights behind her. That looks nice. Patrick, did you see Matthew's mustache?
Yes, I did. We had a lunch meeting yesterday, and so yeah.
It looks good.
Yeah, it does.
I like it too.
It's been a couple of years since we been together again. So
good.
I can't grow a full head of hair like Patrick, so I have to migrate it down to the face.
Lori, good to see you again. Glad you're here.
Thank you. Thank you.
Let's see what time it is. 6:03. So for the sake of time, I know we've got a lot of information to cover tonight, so I don't want to wait too late to get started. There's a couple more that just came on. So I think we'll go ahead and get started and introduce once again our wonderful sponsor, Patrick McClanahan from CIT Bank. I'm going to let him introduce himself, and as the Vice President of CIT, he's sponsoring the evening. My name is Georgie Rasco. I'm the Executive Director of Neighborhood Alliance, and I have with me tonight Sarah Lawhead. She is one of our staff members. She's a community organizer for Neighborhood Alliance and a graduate of Oklahoma University as well in Norman. So she is going to be doing the technical work for us this evening. So at this point, we'll turn it over to Patrick and let him tell you more about the joys of being with an out-of-state bank and how that can really help you and your HOA in many, many ways. Thank you, Patrick.
Oh, you're welcome. Thank you, Georgie. I've really enjoyed sponsoring these, and with CIT, the division that I work for is called CAB, which stands for Community Association Banking, and we're dedicated HOA banking. I'm a dedicated HOA bank, and I travel, take my briefcase, and I travel 8 states, and I just talk to board members and management companies that process your assessments. So we have technology to help those management companies process those receivables, your assessments quickly, and then we loan the money out when you need a project. So say your funding is a little shy, your reserves are a little shy, and we actually loan to HOAs. And the significance of that is it basically gives you guys an option. Instead of that special assessment that may be really high, you can stretch out that project cost over so many years at a lower price point for each individual homeowners. The key point here too, from an HOA and a board member standpoint, because all you guys are pretty much board members, is to keep an eye on those delinquencies. So like a mortgage, your house is the collateral, but in an HOA loan, it is your receivables or your assessments. So we look at that very closely and make sure that it's less than 8% of the total number of doors or houses or condo units. And as long as you keep it low like that and you're following your policies, and Matthew's going to be talking about that tonight, you're good to go. And I can help you with that upcoming project, a pool, a resurface of the road, streets. I've done many of those. So I'm here to answer any questions, and I'll be happy to help any one of you all. And I'm back in St. Louis, by the way. I was in Oklahoma. This is my home office. and I beat the wind. Are you guys getting wind like crazy? I think there's another storm coming. I'm really surprised that everybody's here tonight didn't get blown over. It's pretty bad.
We're from Oklahoma. We're used to a little wind. This is just a little bit of wind. This is nothing to us.
All right.
But it is windy. It is very, very windy. Thank you again, Patrick.
welcome.
You and CIT are very, very important to us, and we appreciate you.
Thank you.
So again, tonight, our speaker is Matthew Winton. To know him is to love him. What you didn't know about him you learned, of course, that he's an iconic and well-respected lawyer in Oklahoma and even in the Southwest, about especially when it comes to homeowner associations, condominiums, and townhomes. What you didn't know is that he's also raises organic beef, cattle from a cattle ranch. He taught himself. He didn't grow up on a cattle ranch. He taught himself and his family how to do it. He also runs 2 restaurants, one in Luther and one, or his family does, one at the Cowboy Hall of Fame as well. It's a wonderful place to go for lunch. So he's a well-rounded cowboy and country lawyer and city lawyer and HOA expert. So you're learning from the best here tonight. Just a fabulous guy. So we'll turn it over at this point to Matthew Winton.
Well, thank you, Georgie. I really appreciate that, the very kind, generous introduction. Patrick and the wind reminded me of that old Ronald Reagan joke about, and I don't know if it's original with him, but about the wind stopped blowing in North Texas and all the chickens falling over, or something along those lines. It sure felt like that in Oklahoma today. Just incredible wind. So this is part 2, and Patrick and I had lunch earlier this week, and he had a great suggestion. You know, I get tired of listening to my own voice sometimes. I know for a fact other people do too. And so in order to try to minimize the boredom aspect that sometimes sets in on a Zoom call or a Zoom presentation like this, we can continue. If you have questions, use the chat feature, but there's also a hand raising feature. And so Patrick's using that. So then what we can do is when somebody raises their hand, if you want to, instead of typing out your question, just raise your hand and I'll unmute you, and then you can just ask your question. And that kind of gets us back to the original format. You know, Georgie and I have been doing these for years, over a decade, and they're pre-COVID, they were all in person. And it had such a different dynamic. I mean, there's benefits to this. We're all at home. We all, you know, are in our comfort zone, and that's nice, but it's not being in person. And there's something very different about being in person, as we all know, over the last year or so. So maybe in order to get a little more of that, if you have a question, then just raise your hand. We'll unmute you. Take 30 seconds, 45 seconds, something like that, just so that we don't use up a bunch of time. And then I don't know if I can unmute you. I can just ask you to unmute, I think is, Patrick, let's try that.
Yeah.
Okay. So I know you can unmute because you're a host on here.
Yeah, so the button is under reactions. If you see at the bottom of your screen, it has like a little happy face with a plus symbol on it. You click there, and then it says raise your hand, and then that way we're just like back in school, you know?
Right. yeah, that and that we were talking about this. We talked about this in part 1, where one of my things that I will do for meetings, particularly if I know it's going to be a contentious meeting, is I will schedule it at an elementary school library or an elementary school cafeteria, because, you know, everything is minimized. You know, you go to the restroom. I don't know if the ladies' rooms are like this. The men's rooms are. They're just small, you know, and the seats are small. The urinals in the boys' restroom are small. Everything is small, and it's kind of hard to be a tough guy when you're sitting in a little bitty chair at a very small desk, and it helps with keeping people on their best behavior. So yeah, raising your hand, we'll try that. All right, so tonight is part 2 of HOA legal issues. We're going to take a little bit deeper dive into some of the topics that we introduced last week, primarily the enforcement. I know that's one question, or that's an area that a lot of people have, rightfully so. The idea, the techniques, the remedies, the ability to resolve conflict, and how do you do that? How do you win and get all your money back, right? That's the question that I get quite often. We're gonna take a deeper dive into that. We're gonna talk about one of what appears to be one of the major functions of community associations, and that's collections, the different types of assessments. So before I get into that, I want to reiterate a couple of things that that Patrick said about CIT. So these loans that Patrick offers, and by the way, this is not paid programming. I'm not a paid sponsor, so don't worry about any kind of bias. My bias comes in that I represent a whole lot of community associations across this state. Primarily Oklahoma County, Tulsa County, and then emanating out from there and kind of bulked around the resort communities and counties. And I have a number of association clients that have used Patrick over the years. And what they're looking for is to loan money to well-run, well-operated, well-managed homeowners associations. And so the things that we're talking about tonight, as far as collections, watching that collections rate, and Patrick mentioned 8%. That's, you can do the math for your neighborhood and see how many delinquencies that is. But interestingly enough, one of the things that we're going to take a deep dive tonight on is amendment projects. So how do we amend our governing documents? We're going to talk about that. Well, there's no crystal ball that can tell me as legal counsel whether a particular project is going to be successful or not, right? Just like no lawyer on this planet can tell you whether you're going to sue and win and get all your money back. Any lawyer that tells you you will, they're lying to you. It's malpractice. You need to find a different lawyer. But one of the questions that I ask a client when they come to me and say, hey, we would like to amend our covenants. One of the questions I ask is, what's your collections rate? What is your arrearage percentage? And so not only do companies like CIT and Patrick want to have some kind of idea of, all right, what's this credit risk? Are they well managed? What's the likelihood that they're going to repay this loan? I look at the exact same things when I'm asked to be counsel on an amendment project. And it's because we're trying to deal with some rule of thumbs and overall trying to get an idea of, is this a well-run, well-managed, administered homeowners association or condo association? So the things that we're going to talk about tonight, if you have a roadway improvement project and the membership keeps slapping it down saying, nope, I'm not going to approve a $1,000 a unit special assessment. Well, maybe you need to focus on some of these things, making sure that you fit within the pipeline for the underwriting guidelines, and then talk to Patrick about funding opportunities. So they're out there. You don't have to despair. Don't lose hope. There's very good available remedies out there for you. Okay, so with all that, let's see. I said my bit on CIT. I told my chicken joke. I've got my my checklist here. I'm going to share my screen and all right. So very quickly, I'm going to run through some of the same slides. So by the way, I have not put it up yet, but I will. I have the video from part 1 also with my slides. I will put that on the blog, which I don't know, can y'all can see my cursor? Can you see my little hand?
Yes.
Okay, so my little hand is next to HOA Blogs. That's a blog that I host. I will put the video on there along with the slides. And then if you have any questions, comments, missed something, misheard something, or thought you heard something, My email address is here. Just shoot me an email. Once again, I'm not providing legal advice. It's an education seminar. I'll do my best to get you on target or in the right direction for what your question or issues are, but don't go away from these seminars saying, well, our lawyer or my lawyer told me this and run with it. I'm only your lawyer if your association has entered into a written engagement agreement with me or my firm. Okay, very quickly, because it's important, if you're not aware of it, it's a really good resource in Oklahoma, and that's oscn.net, Oklahoma State Courts Network. All of the law in Oklahoma is free, available online, and I give you the list here. Okay, let's talk about assessments. Now, I'm probably going to float in between using the word assessment, dues. In my mind, they're synonymous. I know some people want to make a distinction. There's no distinction in my mind. So there's typically 4 types of assessments or dues. Now, last week we talked about the law. We talked about governing documents, where to find governing documents, what they are. The difference between covenants and bylaws. Covenants, remember, are filed with the county clerk's office. Covenants deal with structural and use restrictions. Covenants are going to answer the question, do we have a mandatory association? What kind of dues do I have to pay? All right. Now, bylaws might also have some of that language, but if we want to answer the question, how do we adopt a special assessment? Do we have the ability to fine? Do we have to have a reserve assessment or a reserve fund? We're going to first look at our covenants, our filed covenants, right? I know there's lawyers out there that will give you the opinion that you can adopt specific or individual or fines through just board rulemaking. That's not the law in Oklahoma. It's not the law in a number of other states. So I'm not quite sure where that comes from. Until it is the law in Oklahoma, if you want to answer the question, can our association fine? In other words, can we make people pay the association money for not doing what they said they were going to do or doing what we told them to do under the covenants? That language has to be in the covenants. All right. So the 4 types, annual, you'll find this also titled or named differently through different covenants. In my covenants, if it's a neighborhood that I assisted the developer, they're going to be called base assessments, BASE. But again, it doesn't make any difference if you call them regular, annual. In condominiums, typically they're monthly assessments. So this is the regular accruing, typically annual, one-time basis. Again, condos sometimes monthly, that funds the general operating expenses of the association. It's not intended to go into a bank account and address upcoming maintenance items. It's not a special purpose. In other words, it's not an amount to help us pay for the playground or pool we've been saving for. It's to pay OG&E, it's to pay the light bill at the clubhouse, to pay for the insurance, to pay for the lawyer if you need one, to pay for the lawn person and landscaping. You know, the things that we know that we have budgeted for. That's what annual or base assessments go for. Now, special assessments. This is where things sometimes get tricky and where we have to know our covenants. We have to know what the language says and means, because if you ask me, well, what is a special assessment? I'm going to tell you, well, generally special assessment means to me an extraordinary amount or charge that sometimes the board can adopt, but most of the time it takes a vote of the members, 50%, 66%, and it goes towards unanticipated expenses. We have a sinkhole developed in the private road, and we certainly didn't budget to fix that. Special assessment would go for that. There's a case in Tulsa County where the city came through, they were doing some road reorganization, and it took out some of the common area, took out a part of a gatehouse, and that is an unanticipated expense. You adopt a special assessment to pay for the repair or improvement. I say you have to watch this because I have a condo association in Tulsa County where you read their special assessment clause, and the first paragraph reads like I just explained it, this extraordinary expense. And then there's a second paragraph, also called a special assessment. And that language is more like a monetary penalty. It's not something that all of the owners of the board would adopt for an extraordinary expense. The language says a special assessment also means a charge by the board to a unit owner for costs incurred by the association or according to a monetary penalty schedule. So you have to be careful sometimes and read that. By the way, if you read the Condo Act, if you read REDA, the Real Estate Development Act in Oklahoma, not a word, not a provision, nothing dealing with special assessments in Oklahoma. So the law is what your covenants say. And by the way, so if your board says, hey, we need to raise some money here and we need to adopt a special assessment, and your covenants don't say anything about special assessments, guess what? There is no special assessment. You have no authority for it. There's nothing in the statutes that says, well, this is how you do it, and this is what you can and can't do. And if your covenants don't mention it, well, then you don't have special assessments. All right. Patrick.
I just wanted to mention what I'm seeing in other parts of the country. And I didn't mention this at our meeting the other day, but one of the things that we see, and I'm seeing, and I know we've talked about this in the past, is lack of quorum on annual meetings. And some of these, one of these covenant changes that I'm seeing in Missouri in particular is that the assessment really isn't set in the covenants as a flat fee. It is basically created by the annual budget. So based upon the budget and the line items, typically there's a reserve line item. Then based upon that, then the annual meeting, the members there ratify the annual assessment or the monthly assessment based on their projected budget. Have you seen those in Oklahoma?
Yes. So that is, that's the approach that I take with the covenants that I draft for new developments. And it's a combination. So one of the things that we try to do, whether it's with communication through clearly drafted covenants, kind of forecasting, all right, what are the issues that come up here? And lack of quorum is a big one. That is a constant challenge with a lot of these associations. And so knowing that people like to nitpick and they will find something to try to argue about or to disallow a certain assessment, I actually in my documents take a both and approach. So in my documents, I have an exhibit that I specifically set out what the annual base assessment is. I have the developer tell me what the initial base assessment is. So we have a number in there. And then if we want to increase that, the board has the ability to increase it 20%, which is a huge increase. And you would never get resident owners to agree to that. The only reason you can have a 20% increase by the board is because the developer puts those covenants in place. But what the board also can do is adopt a budget say they want to increase it 15%. They will adopt a budget that provides for that 15%. And the covenants that I draft, it puts the burden on a percentage of owners. I forget off the top of my head whether it's 20% or 25%. I don't remember offhand, but it shifts the burden to the membership that, look, if enough of you disapprove of this budget, well, then you have to come forward. You have to put that in writing, and then that budget will be disallowed, and we have to redo the process. We also have language in there that, look, if we don't have a quorum, if a sufficient percentage of the owners disallow the budget, in other words, if we have a stalemate and we can't get anything approved, well, then last year's budget is automatically approved. And so we have this layering approach of, okay, if this happens, then this, but what we don't want is just a complete shutdown of the association finances. And we also don't want to put all of the power in the board's hands. So we want the board to be free to do their job, to spend the association's money and do so within their fiduciary duty. But we need to have some fail safes, some checks and balances, and that's what we try to do with that. Look, if enough owners vote to disapprove the budget, well, then the board has to redo the process. So one of the questions is it a hard task to add this language to your covenants? Hold that question. We are going to fully answer, well, maybe not fully. We will do our best to answer a lot of that with the covenant amendment. And I'll get to that in just a second. That's one of the major portions that we'll talk about tonight. Because if there's things in your covenants that aren't there that we want there, well, that's how we get them, is we amend our covenants. So the next thing, and this is probably the number 2 covenant amendment project that I'm doing currently. The number one is some kind of language dealing with leasing, Airbnb, maybe small home-based businesses, trying to get some language on, okay, what does this look like for our neighborhood? What is the general consensus or agreement of how we're going to use our properties for business purposes? Because it's a given. It was a given before COVID and everyone went home and started doing work from home. It was a given that there was going to be some kind of home-based business. I mean, every house that I've lived in since 2000, and I became a licensed lawyer, I was practicing law out of my house. Now, my clients weren't coming there. I wasn't doing depositions, but I work in the evenings like a lot of people do, and I was doing business. Now, there's no way in the world you would know that. And there's a number of businesses that it's no skin off anybody's nose. And so a lot of times we'll amend. But so this next one, specific or individual assessments. These are fines. These are monetary penalties for people not doing what they said they were going to do, or not doing what the majority of the neighborhood has decided. Hey, look, these are the rules for our neighborhood. You know, you don't paint your house pink. You put your trash can up when you're supposed to. You don't let your dog run all over the place and tear up people's yards, whatever that is. The very best, I'll say very best, the most cost-effective means to enforce things like trash cans, trailers, boats in driveways, all of that stuff is specific individual assessments. It's not because a lawsuit for an injunction is not available. It's just an expensive remedy. And we'll talk about covenant enforcement here in a little bit too. But if you don't have specific individual monetary penalty language in your covenants or in a set of filed bylaws, well, then you can't just make it up. Just like you can't make it up that somebody's a mandatory member of an association. The only way you can be a mandatory member of association is there's a covenant of record that says the owner of this particular property has to pay this homeowners association dues. It works the same way with specific assessments, right? So I don't want anyone to go go from here and say, well, we watched this video, this lawyer said fines were fantastic, they were very effective, and so now we're going to start fining people. You're not, only if the covenants that are applicable to your neighborhood specifically allow for it. Something else, and we'll talk about liens in a second, but just because your covenants say you can charge annual dues or special assessments or specific individual assessments, that doesn't mean you can file a lien against people's property because they don't pay it. The only way you can file a lien for non-payment of mandatory assessments or dues is if the covenants provide for it. So if you go to Title 60, Section 521 for the Condo Act, or Section 852 for the Real Estate Development Act, what you'll see is language that says, association, you can file a lien provided your covenants allow for it. So once again, the law doesn't say if you can charge mandatory assessments, then you can file a lien. What it says is if you can charge mandatory assessments and your covenants provide for a lien remedy, then you can file a lien. We have to be very, very careful that we understand what we're doing when it comes to filing liens against people's property, because there's a very nasty claim out there that exists called slander of title. And slander of title comes with not only actual damages, but also possible punitive damages and attorney's fees if you wrongfully file something against someone's property. All right, so let's talk about just some nuts and bolts on collections. Okay, I find some clients, there's nothing wrong with this. I'm kind of chuckling just because it's very old school, but I find some clients still using ledger paper and handwriting accounts. Patrick will freak out if you bring him that and try to get a loan. Now, Patrick doesn't freak out, but he will gently encourage you to modernize a little bit, just as I would when someone brings us a collections file. We have a vetting process, and if what we get is a stack of handwritten ledger sheets, we're going to strongly encourage the client to digitize. Not only does it make things easier for the client, for the debtor, the member, owner, and the professionals dealing with them, whether it's the accountant, the lawyer, or the banker, but it also greatly minimizes the chances of accounting mistakes. Okay, and when it comes to collections, we have to make very certain that the amounts that we're trying to collect are accurate. So if we've misplaced a 1, if we've added a 2, and we've gotten our numbers wrong, that's something that we simply can't do in the collections process. And having accounting software minimizes that. I think I mentioned this last week, but the collections case, in other words, communicating to a member that there's this expectation, this requirement that they pay their dues on time, in the right amount, to the right person, it really starts right before they close. And so if your association can have a welcome home committee, a welcome home person, some kind of communication that goes to the buyer at closing that says, this is who we are, this is what we want you to know about us. One of the main things we want you to know about us is that we're so glad that you're our neighbor and that we can't wait to meet you. Here's the information resources that we provide. Here's our website. Here's how you get your clicker, your gate clicker if it's a private road community. Here's the rules of the pond if it's if there's a pond. Providing almost like the guest book that you would find, or that you would expect to find at an Airbnb, right? If you've ever used an Airbnb or a VRBO, you've been to one that does a really good job of anticipating all of your questions. We went to one in Denver a few months ago, you walk in the front door and she had all of the guest book information in framed pictures on the wall. And I'd never seen that before. It was fantastic. You didn't have to worry about, well, did the prior guest stick the guest book under a pillow and now you got to tear the place apart looking for it? It was right there on the wall. Of course, it was pretty. It was very well done. And then I've been with others that you're like, okay, just tell me the Wi-Fi passcode, right? I mean, don't bury it at the last page. Just, everybody needs the Wi-Fi passcode. So you could take the same approach with your customer service, starting with thinking in terms of members as customers and how you're providing them customer service. All right, I won't speak more on that. I know there's words and other bullets on this slide, but we're going to cover them more on these other slides. I want to spend a few minutes talking about collections. And the reason I want to do this is because my firm spends a lot of time in collections and we see a lot of mistakes. Usually they're not that big of a deal. Some of the mistakes can be significantly costly to the client, to the homeowners association, possibly individual liability for board members. So what do you need to know about collections? So the first thing is you need to know that there is a law called the Fair Debt Collections Practices Act, FDCPA. FDCPA is the federal law that was adopted many years ago that keeps debt collectors from calling you and saying, they're coming to your house, they're going to put a gun in your mouth, and if you don't pay them, they're going to, harm you or something that you love, right? I still get, it's not very often, thankfully, where elderly clients will get a phone call that someone's going to put their grandchild in jail unless they pay this amount. I mean, that is absolutely illegal. You cannot do that, right? Everybody knows that. What you may not know is that the same law that prohibits those kinds of strong arm tactics also applies to debt collectors who are lawyers, debt collectors who are HOA managers. And so some of these things that we're going to talk about become very important because if you don't get them right, then you're violating the FDCPA. So this does not apply when the association is collecting its own debt. So what does that mean? If the treasurer of the association sends out a demand letter to an owner, hey owner, you're late, you need to pay up, the FDCPA does not apply to that because creditors are not debt collectors. What a debt collector is someone who collects debt on behalf of a client. Me as a lawyer, an HOA manager that tells you in their management agreement that they're going to collect debt for you, they're debt collectors. So one of the things debt collectors cannot do is lie to people. Well, how am I going to lie to someone? I'm not going to do it intentionally, but if I get a collections file and the board has, say your dues are $200 a year, and the account statement has $200 plus some interest and then a $25 late fee. When those files come over, one of the first things we're going to do is go to the covenants and say, where does this $25 late fee come in? I don't know where this comes from, but we see a lot of accounts with this arbitrary $25 late fee. If the covenants don't provide for a $25 late fee, why not make it 100? Why not make it 1,000? Let's make it really interesting and really painful, and we'll just really ding them for a late fee. Whether it's $25 or $1,000, if the covenants don't provide for it, it's made up, it's fake debt, we can't do it, okay? The lawyer can't do it, the manager can't do it, right? So late fees are a big thing that we find, okay? Sometimes there's an accounting error. Those are simple accounting mistakes. Sometimes what we find is an interest rate mistake, and I understand this. So if the covenants provide for a 10% late interest amount, and we have a set of bylaws that provides for 18%, sometimes what we'll find is the 18% used as opposed to the 10%. What we're going to tell the client is, look, you got to go with the covenant 10% as opposed to the 18%. If you want 18%, well, then amend your covenants to provide for the higher rate. But we can't adopt a policy, we can't adopt a bylaw that supersedes or goes beyond something specifically set out in the covenants, like a late fee. Let's talk about liens, because this is a big one, and I find this routinely, particularly with HOAs that have managers. And by the way, if your association has further questions about this, our firm has a collections memo that I can email to you that sets out the chapter and verse in Oklahoma law as to why an agent can't sign a lien, why you can't keep having your manager just sign the lien and file them. All right. So in Oklahoma, if a person is going to sign something for real property purposes, a mortgage, a deed, a closing statement, a lien, that person either has to be an authorized person, an authorized agent, or they have to have a duly executed power of attorney from the agent or authorized person. And that power of attorney must be filed with that real estate document. So think about this. Have you ever been out of town? If you had a piece of property that you co-owned, whether sibling, spouse, friend, doesn't make any difference what your relationship was, but you were a co-owner of this property, and you were going to sell that property, or you're going to mortgage that property, and you were out of town. Was your friend, sibling, spouse, were they able to sign your name on that document because you weren't going to be there? The answer is no. And the answer is no, because Oklahoma law doesn't allow that. What Oklahoma law says is if that person is going to sign on your behalf, you have to give them power of attorney, and that power of attorney must be recorded with that document. But I find HOA managers routinely signing and filing liens against people's property without a power of attorney. And that creates significant issues. So this is something that I'm not giving you legal advice, but I do want, if you're an HOA board member, to double check your association's lien practice. This is a big deal, okay? Filing liens that are unauthorized against people's property is a big deal, okay? So how we collect assessments if say they're delinquent, the first step is for the association to try to figure out why they're delinquent. A lot of times we'll get a collections case or file in our office, and in part of our vetting process, we will look at the letter that gets sent or the invoice that gets sent to the member, and understandably, it gets sent to the property address, but it's a tenant or it's a child that lives in the property, adult child, and the actual owner of the property lives Florida, somewhere else. Well, if the tax bill for a property is going to somewhere other than the property address, that's something that is a flag for us. And well, maybe this person isn't getting copies of the invoices. And so that doesn't need a lawsuit. It doesn't need a lien. We just need better communication. And so sometimes we can avoid litigation or further complication by just getting the piece of paper or possibly the invoice into the right hands. In the event that we've gone through all of the communication, we've done everything right, and this individual falls in one of those categories of they just don't have the money. They have spent all of their money on whatever, legitimate or illegitimate, and they just don't have the money to pay. They fall into the category of someone told them somewhere that the association can't collect against them, that you can only file a lien and you have to wait till they sell or die in order to collect your money. Very rarely, but amusingly, sometimes we'll get these people who are they're like sovereign citizens. They call themselves sovereign citizens or posse comitatus. You know, there's probably other terms, but these people who think that they're a law unto themselves. I hate to sound like a lawyer, but I love litigating those. There are some people that you just have to convince. No, you bought into a neighborhood that you have to pay this. I'm sorry you don't like the political party that's in control of Washington or the state capitol, but it really has nothing to do with whether you pay your association dues or not. We will try to talk to those people, and the board should as well. But I mean, if you've satisfied your conscience, you've done everything you possibly can, short of litigation, to get this person to get on board and get into the fold. Well, then the next step is litigation, and you can sue in small claims court for money, or you can file the lien and foreclose it. All right, I've got a couple of questions here. All right, is the POA between the association management company a one-time document that can cover all the properties and or have an expiration date? And then Sarah, should an HOA manager have a POA? Is it a good idea? So the way the power of attorney can work. So you can have a durable power of attorney, a limited power of attorney. You can have a power of attorney that is executed for each lien that the manager or agent. By the way, this isn't just an HOA manager. If you wanted me to sign a lien and file it, I can, but it takes a power of attorney from the board to me in order to do that. You can draft any of those provisions. If you want to put a time limit on it, if you want to make it a general power of attorney for all liens, there is some wisdom to tailoring it to either a time or a particular management contract so that you have some definiteness and it's not just this thing out there that you have to try to come back and get control of. So the answer is yes, you can build into some of those provisions so that it's not cumbersome. I mean, and it's no secret why managers do this for boards. It's very convenient. The boards hire a management company to manage, and that includes fielding calls, sending out invoices, and I understand that. However, when we get to debt collection and when we get to filing liens against people's property, now we're outside of the realm of normal management and we're into extraordinary actions. Things like the bankruptcy code and filing liens against people, whether the manager is authorized or not with power of attorney. Filing a lien against someone who is in bankruptcy violates the US bankruptcy code. So making sure that the manager, the lawyer, whoever the third party is, making sure that they understand there are significant laws, federal and state laws out there that apply on how to do this, and making sure the professional that you're hiring knows what they're doing and not creating liability and then just thinking, well, if something happens, I'm named on the association's insurance policy and I'm covered. That's not good enough. Not good enough when we are taking people to court, when we're making demands, when we're dealing with the US Bankruptcy Code and the Fair Debt Collections Practices Act. Okay, so let's talk a little bit about some misconceptions about liens, all right? This uniform application, whether we're talking about liens, collections, whether we give people grace and mercy, whether we give them ability to pay out, whether we waive interest, all of that needs to be applied uniformly. Of course, it should, I would say, it should never occur to us to give those kinds of leniencies to one race over another. We would never do that for one gender over another. We shouldn't do that for people that we like, even though like, dislike is not a protected class. But we need to treat everyone uniformly when it comes to our collections. And I'm saying this not only because it's the right thing to do, but it also makes my job as litigation counsel much easier. Because if I'm standing in front of the judge on the collections, or if one of my lawyers in my firm is standing in front of a judge, and the defendant shows up and says, well, here's some evidence that they allowed this person to do this, but they're putting the screws to me. That's a problem. That's a problem for the association. Apart from just looking bad, it could cost you the case. So treating everyone the same is, it's not only a good idea, it may just very well mean the difference between actually collecting or not. One of the best ways to ensure this is use forms, use policies, find a collections resolution that's drafted according to your covenants, and then just use that as your checklist. Don't deviate from it. If it doesn't work, then change it. Make the language say what you need it to say that works for you. Some of the misconceptions, and I'm going to move on because we still have to talk about amendments and general covenant enforcement, is sometimes you'll hear, well, you can file this lien, but you can't foreclose on it. You have to wait till I sell or refinance or die. Absolutely false. You can lose your home in Oklahoma to a sheriff's sale, to a foreclosure, if you don't pay your assessments. Now, whether an association is actually going to file a lien and foreclose is more of an economics question than an ability question. But there is no question in Oklahoma, if you have covenants that allow for the filing of a lien for non-payment of mandatory homeowner association assessments, that association can foreclose on that lien and sell that home. We've done it in residential, single-family residential. We've done it in condominiums. And so one of the things that associations can do is help their membership understand you don't have the right not to pay and to keep your home. Ultimately, you can lose it. Also, these HOA liens are not MMLs. Now, MML is short form for mechanics, materialmen's, and laborers liens, MMLs. Okay, this is a type of lien. It's a special statutory lien that if I have someone come out, work on my house, they do a great job, and then I'm like, yeah, I'm not going to pay you. They have the ability under Oklahoma law to file an MML. Now, that is a different kind of lien than an HOA lien. So an MML has to be foreclosed on within 1 year. That is not the same thing as an HOA lien. The last bullet that I'll cover on here, one of the things that you need to check and make sure that either your lawyer or the lien form that y'all use, whatever language that you customarily use for your liens, make sure it has continuing lien language in it. I see repeated liens filed year after year after year on the same property. It's a waste of money. It's certainly a waste of money if the association's paying someone to file that lien over and over again. At the very least, it's a waste of filing fees. All you have to do is have a lien that says, our lien covers all present amounts owed. It covers all future accruing assessments, unpaid future assessments, unpaid costs, and attorney's fees. So you have this continuing lien language, because if you think about it, if your association is charging interest, the lien that you file on day one, it's out of date on day two because you have interest, right? It's accrued. So just add this continuing lien language and tell whoever your provider is, quit filing liens year after year. It wastes money, and the only thing it does is really agitate the member. All right. I mentioned that you can collect in small claims. This slide has some detail about small claims. Small claims is designed for very quick justice. These judges hear lots of cases in a very short amount of time, which is one of the reasons why, if your association is going to collect assessments in small claims, we want to have everything lockstep, very clear, no question whether this person received the same treatment as anyone else, no question whether the covenants are abundantly clear on are assessments owed, are there fines owed, all of that. One of the tricky things with small claims, and this is a function of statute, is if you sue in small claims court and the person doesn't show up for trial, meaning you take a default judgment, which is a large percentage of people, they just skip the trial, then Oklahoma law says you are limited to a 10% attorney fee. Now, what that 10% is applied against is the principal amount. So if your association hires a lawyer, they sue to collect a $500 assessment in small claims court, and the individual doesn't show up, the court by law is going to limit you to a $50 attorney's fee. Okay. That is not going to be, that's not going to cover the full amount of the attorney's fee that you're likely going to be charged. So part of the collections equation is evaluation of recovery of attorney's fees. Okay. So maybe you wait a few years until the amount is up there. You can wait 5 years. There's a 5-year statute of limitations for collecting assessment debt in Oklahoma. That 5 years is based on a written contract, the covenants being considered a written contract. So maybe you wait a few years. Some associations' budget can't wait that long, and so maybe you go ahead and have a lawyer send a demand letter. Maybe you bulk a bunch of them. So for example, if you're in dire need of a loan and you go to Patrick and he says, you got to have a collections rate less than 8% or 8% or less, then maybe you go ahead and file all of those cases. You send your lawyer to court on 10 as opposed to just 1. That way the time the attorney's fee the attorney takes and will charge the association is spread out among a bunch of cases. There are ways to try to do that, and your lawyer should work with you to figure out what your collections budget is and how to reach it. I'm going to skip foreclosures because most of the associations here are single family homeowners associations. There might be some condo associations out there, but although we do file a lot of liens for homeowners associations, it's somewhat of a rarity to foreclose on that. Now, one of the things that I want you to hear about foreclosures, because I hear this filter back from clients that they're getting legal advice from their managers, where their manager serves as the registered agent of an association. The manager gets served with a petition. So say I live in the neighborhood, I have a mortgage, I quit paying my mortgage. The mortgage company is going to sue me to foreclose on my mortgage. They're also going to name the defendant as the association as a defendant in that foreclosure. What I hear back sometimes is people giving legal advice that the association should just ignore that foreclosure, that you're not going to collect anything out of it. That is horrible legal advice. And I suggest if you have a manager or if you have a lawyer telling you that, and they're just doing it off the top of their head, get a second opinion or look at it closer. We actually enter an appearance in a whole lot of lender foreclosures because it saves the association the filing fee. It saves the association the service of process fee. Basically, the association gets to tuck in behind the lender and follow them to sheriff's sale. It's a very, very cost-effective way to end up with a judgment, not only for sheriff's sale and possibly payment out of the sheriff's sale, but at the end of the process, guess what? You end up with a personal judgment just like you would if you had sued in small claims court. So it's ridiculous that someone would get served with a petition naming the association as a defendant in a foreclosure, and someone would tell the board, oh, just throw it in the trash or ignore it, you won't collect anything. There is no possible way that individual can give that opinion. Definitely can't give that opinion if they're not a lawyer. So take a different approach in looking at those lender foreclosures if that's been your association's practice. There may be an opportunity that you're missing there. All right, I'll tell you one of the things about bankruptcy, then we'll move on. When a person files for bankruptcy, and bankruptcy is a federal statute, it's called U.S. Bankruptcy Code. When a person files for bankruptcy, there's something called the automatic stay. And that automatic stay prevents any collection activity by anyone, not just debt collectors, by any creditor. So this would include the association. If a person files for bankruptcy and the association, their manager, their lawyer, anyone tries to collect a debt, delinquent assessments from that individual, they have violated federal law. If they have filed a lien against that person and that person is in bankruptcy, they have violated federal law. There's a really easy way to determine whether you're about to violate federal law, and that's you do a check to determine whether this person is in bankruptcy. It's not a secret. You don't have to bite your nails and try to worry about whether you're violating the automatic stay. There are processes to determine this, and anyone who is going to practice collection of debt for your association needs to be set up not only to meet FDCPA, but also to do a simple bankruptcy check. I'm mentioning this because we get collections files in our office that board says, hey, we have some delinquencies, we need you to send a demand letter out, or we need you to file a lien. And part of our vetting process is, because I'm not about to violate federal law, we do a bankruptcy check. And sometimes we find, okay, there's a lien that's been filed against this individual. They were in bankruptcy. You have to go release this immediately, or go tell your manager to release this immediately. No, don't send them any demand letters, anything like that, because they're in bankruptcy. We have the automatic stay. So that's probably the biggest thing that I want you to know. Each case has to be evaluated, what kind of bankruptcy it is. There's different kinds, whether the debt is pre-bankruptcy petition debt or whether it's post-bankruptcy petition debt. Again, this is one of those things where it's possible. The answer is, okay, you don't want to pursue this because it's not going to be cost effective. You won't collect anything, but you don't know that until you evaluate it. Just the sheer fact that someone is in bankruptcy does not mean that the association won't get paid. In fact, in some instances, it may mean that the association is in a better position to get paid than other people. Okay, question. How can the association become aware if a property is being foreclosed on to piggyback on the lien effort? So that's a good question. Part of the process, so you will know, because part of the process is the lender is going to sue everyone who has an interest in that property. So lender has a mortgage against a lot. They're going to sue the lot owner, who's also the borrower, the person who purchased the property and executed a mortgage. If the association has filed a lien, and then oftentimes, even if the association has not filed a lien, if the lender thinks that there's a mandatory association, and they're going to think that because there's a set of covenants on file, they're going to order a title opinion that tells them there's a mandatory association, then they're going to go ahead and name that association as a party as well. This isn't because the association did anything wrong or anything bad. It's simply a function of, we want clear property titles. This also goes back to why we have such the formality of who can file a lien against property, is we demand particularity when we're dealing with real property titles. And so part of the foreclosure process is we're going to sue everybody that shows up on a title report. So if there's a physician's lien, if there's an IRS tax lien, all of those people get named in the foreclosure. All right. Okay, let's move on. So I've got some pictures here. Some of them I cribbed off the internet. Some of them are some of my favorite from various cases. This is an internet crib. This hopefully isn't in your neighborhood and you don't live next to this, but this is what I call the perpetual bulk trash day, right? You've got that person who thinks, if I just put all of this garbage out on my front yard, it will magically disappear. Sometimes we have to help them make it disappear. This one's also off the internet. This wasn't an HOA issue. This was a neighbor to neighbor issue. If you look really closely at those attic louvers, they look suspiciously like a obscene gesture that we give people sometimes. We don't, that we know that people use their naughty finger sometimes, as it's called. This was a dispute that two neighbors got into a scrap. One sued the other one, and then these louvers appeared. This is one from the UK. This is a car lot. By the way, I have these photos in our discussion about enforcing covenants before we get to amendments, because sometimes you wake up and you realize, what do you mean our covenants don't prevent pink houses? And your neighbor has not only, I don't know if this is a yard sale or if it's a shrine or what's going on in this driveway, but there's a lot going on in that driveway. And then, wow, you have a very pink house. This is an actual picture. I think this was a Texas case where individual paints the stone, paints the stone and paints the roof shingles pink. And the neighbors, of course, go ballistic. And then they find out there's nothing in the covenants that would prevent this. So this is when we were talking about kind of forecasting and thinking ahead in terms of what language do we need to protect us, or what kind of channels do we need in our covenants to protect against something from us waking up and finding a pink house. Doing it before this happens, because once it happens, you can't retroactively adopt a covenant that says no pink houses and then make them change it. It doesn't work that way.
Isn't that a Bruce Springsteen song or something like that?
John Cougar Mellencamp.
John Cougar, yeah.
But that's not a little pink house. That's a really big pink house with with painted stone. Wow. I gotta think that there's something more to this story. I mean, that's not just pink. That's almost like a spite pink, right? You hear about spite fences, people putting really ugly fences up or something. That's got to be spite pink. So this actually is a spite toilet, and one of my favorite pictures. And in fact, this toilet appeared on this guy's. This was a medical doctor, sharp guy, knew how to read his covenants, and the association board had received legal advice that they could adopt monetary penalties based on rules. And so I can't remember what the underlying issue was. So they adopt a rule-based monetary penalty against this doctor. He reads his covenants and forms the opinion, the correct legal opinion, that you don't have the authority to do this. If you want to fine me, it has to be in the covenants, and you don't have the authority to do so. So they set off finding him, and he decides, you know what? I have a new planter that I want to put in my front yard, and that's what this was. Very creative. Thankfully, the manager of that association came in, recognized we have a significant problem here. We have a problem that doesn't need to be resolved in litigation. It just needs better communication. And we were able to come in, give an opinion on the covenants, and bless the board. They were willing to say, okay, yeah, it makes sense. We see what you're saying. We see what the doctor's saying. And we were able to resolve it, and the toilet went away, and it did not take a lawsuit. So I know a lot of times the idea is we need to have a judge tell them, set them straight. Sometimes it just takes maybe some communication and understanding and recognition that the covenants don't do what we would like them to do. This was a case that we actually did litigate. This was, run of the mill, trashy yard, kind of case, nuisance, noxious, offensive activity. This is an Oklahoma County case that we worked to minimize the visual impact. The property owner considered this art, which is very difficult to tell someone what is art. These are tough cases, by the way. It's really tough, to go into court and say, well, judge, yes, this here is a snowman, but it's July. Okay, so what we're asking for is some kind of seasonal balance for these displays. It's much easier if we have covenant language that says something about signs, seasonal displays. If you don't want lights on people's houses in the middle of summer, well, then have covenants that say that. Most people don't, and it's usually not a problem. So what do we do when we have these covenant enforcement issues? I already mentioned, well, we have to make sure that we have clear covenant language. Assuming that we do, we will encourage the board to communicate with the individual, prevail upon this person, go talk to them the way you would want to be spoken to if you were in the situation. Is there something we're not seeing? What's that minority voice that we talked about last in part one a couple days ago? What's that minority voice that maybe we need to listen to that has some wisdom that we could follow? If we've done all of that and the case or the file comes to us, we're going to evaluate it to see, all right, is there something that the association could do that hasn't been done? If the answer is no, we're going to look to see if the covenants or the bylaws provide for any due process. Is there a hearing process built into the governing documents where the entire board needs to offer this individual the opportunity to come, present their case to the board, and the board makes a decision? If we've cleared all of that stuff, then our firm or the association's lawyer typically will send a demand letter. Now, this demand letter needs to clearly communicate what the issue is, the grounds for or the basis for the enforcement action, covenant language, bylaw language, policy rule, whatever. It needs to specify whether the board has authorized the filing of litigation, or is it equivocal? If you do this, if you don't do this, then we might do this, or we could do this. Or is it unequivocal? Do this by this date, otherwise the board is prepared and has authorized the firm to file a lawsuit. Now, what would that look like? If we've adopted monetary fines, that lawsuit may be in small claims court to collect those fines. If there's damages, so sometimes the issue is individual has made an improper or inappropriate unauthorized use of common area. So sometimes people think that the common area is partially theirs. They're a member, they pay their dues, therefore they can do what they want with the common area. I understand that. It's just a non sequitur. Yes, they are a mandatory member. Yes, they do pay their dues, but no, they don't own the common area. They don't get to do whatever they want to with it. The common area is the association's property. The common area, the members get to do with the common area what the board says they can do, or what the covenants say they can do. So for example, in a private road community, the covenants more than likely say that the association owns, maintains, administers the common area, including the private roads, and that the individual owners have a non-exclusive easement to use the road for ingress, egress, for police, fire, guests, all of that stuff. That doesn't mean that individual owners can set up some kind of speed trap and charge people fines for driving faster than what they think they should. The association absolutely can do that. There are associations that are large enough and have a need to adopt basically a private traffic fine system. But individual owners don't have that right. they don't have the right to fence around a portion of the common area and then treat it as their own. So sometimes these cases involve damages. A lot of the covenant enforcement cases are going to be brought in district court. Okay. The reason why we this sounds weird, but the reason that we like fines or monetary penalty systems is because it gets us away from injunction lawsuits. So injunction lawsuits are asking a court to enforce a covenant, either with a prohibitory injunction, judge, make them stop this, or a mandatory injunction, judge, make them do this thing. It's not that injunctions aren't available. Injunctions have been around for a very long time, and it's kind of the go-to, the traditional remedy for covenant enforcements. It's just judges are hesitant to jump in the middle of people's issues, particularly if it seems like this is going to be an ongoing issue. The judges want a ruling and to be done. And the more we can make that ruling like what the judge experiences in other cases, like breach of contract cases, negligence cases, car wreck cases. In those cases, you don't get an injunction. You know, if you and I enter into a contract and I don't do what I'm supposed to do or what I said I was going to do, you don't get to go to court and the judge orders, well, Matt, do what you said you were going to do. And we're going to make sure that you do what you said you were going to do. You get money, right? Or you get money back, or you get out of some obligation. If you run over me in a parking lot, you destroy my foot, I don't get a new foot in the lawsuit. I get money, right? That's the reason why we like monetary penalties for covenant enforcement, so that we avoid these long, expensive injunction lawsuits, and we're tailoring the issue, or actually the ultimate remedy, close to what a judge is used to. All right, there's an emoji. I'm not sure what the laugh is, but all right. So
It was for the bubblegum pink house.
it was what?
It was for the bubblegum pink house.
Oh yeah. Yeah. Okay. I want to end with this. I won't belabor the point, but again, having a board who is oriented or at least open to asking the question in high conflict, even mild conflict situations. Okay, is there something that we're missing here? Are we seeing the first picture and it's actually the bottom picture? It just takes one person on the board. And this is, again, why we have boards and not just me running things, because I miss a lot. I rely on people around me. Matt, come on. What about this? Oh, now that you mention it, that makes perfect sense. Be that person on that board. Don't be shy about, hey, is there something that we're missing? That's a simple question to ask. It's very non-offensive. Before we send this to the lawyer, is there anything that we're missing or that we can do, right? Very good practice. And you don't pay attorney's fees if you find an answer, right? Okay, now I want you to read this. If you've taken this course before, you've heard the joke, but I want you to read this. I want you to soak in its horribleness. This is a terrible, terrible covenant. Unfortunately, I did not make this up. I have reproduced this covenant verbatim. And when I say verbatim, I'm using it in the literal, classic sense of literal, even down to the punctuation, the underlining of running, the single quotes, even though it's not within a quote, the open parenthetical that never closes. It's terrible. So, and who knows what this even means? I mean, it could mean something very, very offensive to people who are handicapped, It actually means, the intended meaning, it's supposed to put in place a sportsman ethic or a sports ethic, where if you're hunting ducks, the reference to cripples is referring typically to ducks or possibly geese. But it's unsportsmanlike to shoot a bird on the water. You can't just run up there and pop, and then you just start blasting them on the water. That's supposed to be unethical. I know some people say, well, shooting a duck anywhere would be unethical, but in the sportsman world, traditionally, you can't shoot them on the water unless they're wounded, and then the idea is you put them out of their misery. All right, so that is why this language was drafted. They just got it horribly, horribly wrong. Well, what happens if you have something this bad, or maybe something not quite bad, as bad? What if you want to have monetary penalties and you don't find that language in your covenants? What do you do if you find yourself being overrun by Airbnbs, and you don't want to stop leasing completely? You just got to get some kind of semblance of order. Well, you do that with a covenant amendment, right? If the existing language doesn't meet the function of what you need for your neighborhood, or if you have a need for your neighborhood and the covenant language just is absent, or if there's language that's defective or ineffective, like for example, it's really common for clients to come to me and say, hey, we had somebody put up a pink house. They didn't get architectural committee approval. What do we do about that? The first thing that I'm going to look at, I'm going to ask the question, which the clients often don't ask. They've just kind of assumed. But the first question I'm going to ask in that situation is, do you have a valid architectural review committee? Right. So when it comes to covenant enforcement on a structural restriction like that, outbuilding, solar panels, pink houses, we're usually looking at two covenant clauses. The first one is the mother may I, or the Simon says. Whose permission do you have to get in order to do something on your property? And then the second is, what do the covenants say in terms of, can you do this or can you not? Regardless of whose permission you get. So if you find that the covenants say the architectural committee shall be the developer, the developer's brother, and the developer's spouse, and then period, that's it. Well, the board is not the architectural review committee. We have to follow the covenant language. The fact that there is an association, the fact that your association has acted like the architectural committee for a decade, doesn't mean it's the architectural committee. And if we find out, okay, we need to fix this, a covenant amendment would fix that. Okay, so if there's those kinds of reasons why, the next question is, okay, well, how do you do it? So there's two things that we look at. One, hopefully the covenants themselves have an amendment clause. You're looking for some language that says these covenants shall run with the land and be binding on the owner and property for the next 10 years, at which time they will automatically extend for another 10 years. That's kind of a common, unless otherwise amended by a majority or 3/4 or whatever the percentage is. That's a real common amendment clause. Okay, we have to be careful. And again, if the language says these covenants run with the land until such and such date, at which time a majority of the owners may amend, otherwise they extend for another 10 years. That language means you get that percentage, majority, whatever it is, on that date. You don't get it the day before, you don't get it the day after. We have to be very, very clear on what the covenant says. And that's probably one of the biggest tripping points that I see, where a client comes to me and says, hey, here's a covenant amendment that we did. We want to do this. We want to enforce our covenants. And they have assumed that their covenants are enforceable. Well, part of my vetting process is I'm not going to get into court and be standing with a set of covenants and find out then that they're not enforceable. I need to know. It's the attorney's job, right? You hire us to ask those questions. I need to know, are these covenants enforceable? And so I ask the question, what document can I rely on? And so part of our process is we created a governing documents file. I have an index that I want to track all of the language. And if I have a covenant amendment that's filed that the client hands me, and it's signed and notarized only by the board president, a huge red flag goes up, because very, very few covenants can be adopted and filed by the board themselves. I'm not going to say it's impossible. They are out there that can be done that way. It's just very, very few and far between. So one of the things, if y'all are operating off a set of covenants that were adopted and filed just by your board of directors, you might double check that, because if the prior covenants say the covenants can only be amended by a majority of the property owners, the lot owners, well, that's not the board, that's not the association. So that's a hallmark of, okay, maybe we need to fix this. It's not the sky is falling. It just means that the immediately preceding covenants are the operative document. But we have to be careful in terms of who are the proper people, what is the proper entity for adopting a covenant amendment. Another thing to think about in terms of covenant amendments, and I get it. I understand why clients convulse when I tell them this, because it's hard. This is not easy. It's the notarized ballot requirement, right? And so whenever I tell clients, okay, based on the way your covenants are written, you have to have notarized ballots, and that ballot has to be signed by both property owners. So if husband and wife, wife, whatever the gender, whatever the composition is of that property ownership, if you bring me a ballot, it has to be signed by everybody. Okay. And in most cases, that ballot has to be notarized, right? And so usually what that triggers is, well, what if we just get one signature and they sign for both of them? What I'm going to say is, you remember that seminar that I did online where I went through that big spiel about how important real property titles are, and your HOA manager can't file liens without a power of attorney? And it's the same thing. It doesn't matter if you're married to them. Marriage does not convey the right under Oklahoma law to sign for people on the real property title, because who's ever heard of a spouse lying to their spouse, right? And doing things behind their back. We're just going to cut all of that out. And if someone's signature is going, or if someone's vote is going to count, their signature has to be on that ballot. And so usually what I hear from clients is, well, what if we send them a ballot and they don't send it back? We're going to count that as a yes. No, this isn't the Random House CD scam like, when we were kids. Remember when the CD companies would send you a CD, and if you didn't send it back, they just kept sending them to you and you were responsible for them. They can't do that anymore because federal law caught up with that. But we can't do that with our covenant amendment projects either. All right. We have to do the hard work. Now, there are some covenants that treat covenant amendment projects like corporate votes, meaning you don't have to have a notarized ballot. Those are few and far between, and it is a really good idea to get notarized ballots anyway, just so that there's no question we have our vote, right? Because the first thing that I'm going to do if an individual hires me as defense counsel, and like I said, I represent real estate developers, represent a whole lot of associations. I occasionally represent individuals whose associations are getting after them about something. And the same questions I ask as associations counsel, I'm going to ask as defense counsel. And I had a case in Norman where an individual came to me and said, hey, I bought this rent house and the association is telling me that I can't rent it and they filed suit against me. Is this something that they can do? Well, I just start asking the questions. Is this a valid amendment? And the answer is no. They didn't get anywhere near the votes that they needed. They didn't have all of the owner's signatures on a ballot to count it. And that association wound up not only dismissing their lawsuit, but paying my client's attorney's fees. They got it so horribly wrong, they just wanted to get out. So we don't need to get into those situations. We can evaluate what is the proper means to amend our covenants before we start down the road of trying to enforce an unenforceable covenant. And what we do, I don't know what other law firms do, but I like to have roadmaps. I like to have a clear path. And so when a client comes to me and says, hey, we want to amend our covenants, the very first thing I do is I draft a memo giving them my legal opinion on this is the proper way to amend your covenants. It doesn't do anybody any good for someone to pay me $3,000 to draft a bang up set of covenants that has absolutely no chance of ever being adopted because they have to get 400 notarized ballots, and they look at that and say, there's no way in the world we're going to do that. Right. So we take a step-by-step approach. I mentioned in this bullet 11 OS 42-106.1. What this is a state statute that I encourage you to go look at it, go read it. It has 4 subsections, A, B, and C. Subsection D is a special type of amendment only dealing with creating a mandatory association where one didn't exist. So if you're just looking at a regular amendment process, you're looking at A, B, and C. And what it says is, if your covenants have been on file for 10 years, then you can amend with a 70%. The lot owners, the owners of 70% of the lots. Now notice the percentage of the lot owners of 70% of the lots is a different calculation than 70% of the lot owners, right? One of the questions that we want to ask is, what percentage is the right percentage? Is it 100%? Is it 50% plus 1 vote? What is the right percentage? But also, what are we applying that percentage against? Is it a percentage of the lot owners? Is it a percentage of the platted lots? Those can be very different numbers, and we want to make sure that we get that right before we set off down the road. 106.1 also says if your covenant's been on file for 15 years, then it goes to a 60%, the lot owners of 60%. It's been my experience, 60% is entirely doable, unless you're just trying to adopt something that the residents or the owners have said, absolutely not, this is unacceptable. 60% is very doable, particularly if it's a consolidation, a cleanup project. Neighborhoods tooled along for 20 years. You've got all this Class B language in there. You've got all the declarant language. Maybe we need to add some definitions like community-wide standard. Maybe we need to add a limited business use. Those are pretty doable projects, fairly routine projects that we do, and 60% is reachable. All right, somebody has let's see. I understand Oklahoma law states that a majority of member votes to modify covenants is 60%. Our covenants indicate 75%. Good question. Which one takes precedent? So I suppose someone could argue or make the argument that, well, if our covenants say 75, you have to follow the covenants, except that this statute, the history, the purpose of this statute is it's a remedial statute. In other words, the whole purpose of it is to make it easier to amend covenants. It doesn't say if your covenants have a higher percentage, you have to go with the higher number. It just says if your covenants have been on file for this long, then you can use this percentage. So my opinion is you go with the easier percentage. And this is why we do the amendment memo. You can't just simply say, well, the covenants say 75% and our covenants have been on file for 10 years. So statute says 70%, therefore we're going with the 70%. Well, what if the covenants say it's a 75% of members appearing in person or by proxy at a meeting duly called? Well, that puts us in the corporate voting category where we're just looking for 75% of the people showing up and in person or by proxy. We don't have to have notarized ballots. That's a corporate type vote. In that instance, we might want to do the 75% as opposed to the 70% of lots where we have to get notarized ballots. So again, we'd like to know what the road looks like before we set down it. And part of that is, I don't think I have this on a sheet. Oh, somebody raised their hand. All right, I'm asking you to unmute.
Okay, thank you. Can you
Yeah.
repeat what you just said about changing of the covenants when your covenants state 75% required, but the Oklahoma law is 60%, and whether you need to have notarized ballots or not?
Most definitely, sure. So there's two types of votes that we're typically looking at in an HOA context. One vote is a real estate type vote. That is amending covenants. Usually when we're talking about amending covenants, we're talking about a real estate type vote, and that requires notarized ballots. If we're using 106.1 to amend our covenants, it is notarized ballots, right? We have to get each of the lot owners on a notarized ballot in order to count that vote. The other type of vote is a corporate vote. So with corporate votes, we're not so interested in notarized ballots as we are adequate notice, proper notice of the meeting, determining that a quorum is present, and then hitting whatever the percentage is in order to reach our vote. So if we have a covenant amendment clause that says these covenants may be amended by 75% of the members appearing in person or by proxy at a duly called meeting, usually typically there'll be an additional sentence that says, and the adopted amendment may be recorded on the signature of the president and the secretary. If I have all of that language in a covenant amendment clause, we're not talking notarized ballots. We're talking a corporate type voting process. Now, we can go ahead and do notarized ballots because what that does is it allows us to file all of those ballots with the amendment so that anyone at any time in the future can do their own calculation and see they had their vote. So that's what I was saying. Sometimes if our covenant amendment process is more is a corporate type vote, well, then maybe we want to do that as opposed to the notarized 70%. We just have to evaluate which is easier, which stands a better chance. So in most of these projects, whether you're getting regular proxies or whether you're getting notarized ballots, in fact, I won't do a project if the client tells me they're not willing to do this, and that's go door to door and collecting ballots. So The only projects where I see mail out, show up to the meeting, and you get enough votes is in little cul-de-sac communities that have maybe 30 units or less. If you have a neighborhood of 100, if you have a neighborhood of 400, I won't work on the project if you tell me, well, we're just going to send notice out, we're going to have people mail ballots back, and we're going to have people show up at the voting meeting. I can't tell you definitively that the project's going to fail. I can tell you I'm just not going to be a part of it, because I have never, in 20 years, I've never seen one of those projects be successful. And in fact, it usually requires a plan and a lot of lead up, a lot of communication. This isn't something that you just spring on the membership and, hey, here's 30 pages of covenant language that I want you to churn through and approve. I mean, you have to consider most people in your neighborhood have not even read the covenants. I mean, I won't ask for a show of hands. I don't want to embarrass anybody, but a lot of board members get elected to the board without having read the covenants. And so the idea that we're going to send this document out, that people are going to be motivated enough to show up at a meeting, to sign it, it just doesn't happen. It could, just like, you know, comet could fall through and kill me right now, but it's just not going to happen, right? And so we have to have a definite plan. This is another reason why I do an amendment memo, is so that it's in writing. You got to go door to door. And so we schedule these projects over 30, 60, maybe 90 days. Maybe you use social media or email blasts to get people ready. Usually want to try to do one of these projects on the heels of a really successful HOA project. So, you know, if you just, you know, adopted a special assessment and you use that money to put in a playground that everybody loves, you came in under budget, capitalize on that. You know, in 6 months, 8 months, whatever, if you need to amend your covenants, then you can draw on that goodwill. If your collections rate is, or if your arrears is 30%, if it's 40%, what makes you think you're going to get your 60 or 70% of people voting to approve? I mean, you haven't even convinced them enough to send in a check. So, you know, using those kinds of indicators, well, maybe we need to do some community building. Maybe we need to generate some goodwill before it's time to run one of these amendment projects. All right. I've been speaking specifically to covenant amendments, and this is why terminology is very important, because if a client comes in and says, hey, we want to amend our bylaws, my response usually is, fantastic, that's a no-brainer. We can do that, not a problem. And I'm going to start down the road of amending bylaws, because boards can unilaterally amend bylaws. We don't need notarized ballots. We don't even need member participation or approval. We can amend the bylaws just with a board in most cases. Now, the ability, the fact that the board can do it doesn't mean that they should. A lot of times we want to involve the membership. Again, these kinds of projects, they generate a lot of communication. They have an opportunity to generate a lot of goodwill. And so the board has an opportunity. They don't want to miss that opportunity by submitting it to a member vote, getting them in participation with this by just unilaterally adopting it. You can at the end of the day, but why miss that opportunity? But if what the board means is we want to amend the covenants and I'm heading down the road of bylaw, well, we're talking two completely different things. So make sure that we're clear on what project that you're wanting to work on. And I say we, that you, if you're looking at amending the covenants. This is a problem, and unfortunately boards and lot owners get saddled with it by really poor drafting, either by the developer or their lawyer. And that's where they stick bylaw language in the covenants where it really doesn't need to be in there. And sometimes they stick covenant language in bylaws and it doesn't need to be in there. That's a project that we do occasionally, is come in and we'll clean all that up and make it less confusing. I am a big fan of attaching a set of bylaws to filed covenants. I like for my bylaws to be filed. Because that's a notice issue, and it removes one of the arguments of, well, you can't enforce the bylaws because they aren't file of record. You just file them. But they have to be well drafted so that you don't have this conflict between them. Okay, so I'm going to spend the rest of our time. Let's see, I talked about this, except for the one thing, this voting ballot. Part of the evaluation of the project is determining, do you make this an all or nothing, or is this a project where we want to do a line item? And what this means is, so if we're doing an amendment to get rid of basketball goals attached to garages, and we're prohibiting people from painting their driveways, and we're adding a no Airbnb clause, and we're adding a fine schedule, okay? Well, that's the type of amendment that we could do a line item ballot. And what that means is we have separate lines that says, are you in favor of it? Are you against it? You know, initial one or the other. And then it allows for people to get rid of basketball goals, but not adopt a fine schedule, right? With those kind of projects, maybe you want to do a line item ballot. If we're doing a comprehensive consolidation update, we can't do a line item. It has to be an all or nothing thing. Particularly with those projects, there has to be a lot of faith and trust in the board or the drafting committee, because there's a lot of pages. The person's more than likely not going to read it. What they're going to want to do is have someone that they have faith and trust in tell them, we spent a lot of time on this. This is good for the neighborhood. We believe in this amendment. I'm going to vote to approve it. And okay, well, it's good enough for me, right? So that's what that line item ballot. Okay, question. If you have owners that have made changes to their property or land, like before the HOA became active, but are not allowed in the covenant, what's the best way to remedy this? This is a real tough question to answer. It's very situation specific. And so I'll try to get you in the ballpark without answering your question. How about that? So it depends on what kind of covenant violation it is. It depends on whether it's actually a covenant violation. What I mean by that, so if we have a covenant that says only weathered wood shingles shall be allowed in the neighborhood unless otherwise approved by the Architectural Review Committee, and out of the entire neighborhood, you've got one house with an OSU orange shingle, right? And so everyone looks at that and they're like, you know, apart from the fact that it's OSU orange, how in the world is this covenant violation tolerated? Well, maybe it's not a covenant violation. Maybe they got it approved by the Architectural Committee, and we can second guess their wisdom or their judgment, but it's not a covenant violation. So in that instance, if we wanted to get rid of that, now we couldn't change the rules and then go to that person and say, you have to reshingle, you have to get rid of it. In that instance, what we would do is we would take out that language that says, or otherwise approved by the Architectural Committee. And we would have a covenant that says only weathered wood shingles are allowed in the neighborhood. Now, when that roof needed to be reshingled, then they would have to put a weathered wood shingle on. Okay, so that's how we would deal with that. If it's actually a covenant violation, so for example, you put the orange shingle on and there's no possible way they were given a variance or approval. In that instance, we may not be needing to amend the covenants. We may just need to enforce them. In that instance, it really depends on how many of those roof shingle violations there are. And I can't give you a specific number because our Supreme Court has not told us what that number is. They have told us that 2 covenant violations will not excuse a third. What that means is, 2 horses out of the barn doesn't mean you got to let all the rest of them out. I'll tell you the rule of thumb that I use, and that's double digits. If we have a 200 unit development and we're in double digit percentage, 15% of the homes in the neighborhood have OSU orange shingles. I'm not going to be real jazzed about standing in front of a judge and say, hey judge, we need to enforce this covenant, because what comes back is, why now? Why has the association, why has the lot owners, why have they sat on their rights to enforce these covenants? By the way, I didn't mention this earlier. When it comes to covenant enforcement, the association is not the only game in town. Individual lot owners, I may have mentioned this in part 1. I'll go ahead and mention it now because it's important. There is no right of an HOA member to demand that their HOA sue to enforce the covenants. Now they can ask, they can couch it in terms of a demand, but the association board is tasked with making decisions on how the association's money is spent. Part of that decision making can be, we want to spend money on flowers as opposed to lawyers. That's an exercise of discretion. And the response there is, look, we decided we're going to buy flowers, not lawyers, but you're free to enforce the covenants. And that's true. That's the way most covenants are drafted. If you go look at your enforcement clause in your covenants, it more than likely says any lot owner and the association, and by the way, if it doesn't mention the association, it's questionable whether the association can enforce your covenants. But it almost always says any lot owner, any aggrieved lot owner may enforce the covenants. And that's the way it's been for a century, up to the 60s, 70s, and 80s, before associations started really getting going. It was lot owners, neighbor to neighbor, enforcing the covenants, not farming it out to the association. Okay. All right. I've got 7 minutes left. I want to talk a little bit about insurance. I'm not an insurance professional. I don't give opinions on coverage, but there's some things that you need to know and look at and ask your insurance professional about. Right? If you're a condominium association, you need to make sure you have a condo policy and that your individual unit owners have condo unit policies, not some CGL that some guy has sold you. You need to have a condo specific policy. Really, the same thing goes for your homeowners association. Commercial general liability is not the product you're looking for. You're looking for a company that knows how to and will place a community association policy. The various coverages you're looking for: property coverage or casualty. This covers the wind that turns into a tornado and destroys the front gate or the clubhouse, the coverage for that. Liability, someone slipping and falling on the common elements and makes a claim that the association was negligent in maintaining. And then what's called D&O, directors and officers policies. This is the coverage that protects individual board members. And then all of these we want to, and this is the bottom bullet, whatever coverage you have, you want to make sure that that policy has a duty to defend that's broader than the coverages. That's really where we see the benefit of insurance. We don't see a whole lot of associations and their board members having to go to trial on some of the claims that are made, although they do. Slip and fall cases, if there's a question whether the association was negligent in maintaining common areas, then that's a case that goes to a jury sometimes. But we want to make sure that the association's not having to pay month after month, $1,000 after thousands of dollars in attorney's fees. None of my associations have budgets for that. But they do have budgets to pay insurance premiums and include in those policies the duty to defend. Some other coverages that we're finding more important as the years go by, and that's employee dishonesty, cybercrime coverage. It's still pretty rare in community associations, at least around here, where you'll see some fraud and embezzlement, but we do. I've seen cases where it's a couple $100,000 up to $500,000. Most of the time they're under 100,000, but having coverage that will replenish a reserve fund if a treasurer or a manager or a lawyer, anybody makes off with that money, there is insurance coverage for that. Okay. By the way, and Patrick and I did one of these a few years ago. We did a seminar on fraud and embezzlement in a community association context. And one of the best ways to protect against that is to have an active board that meets regularly, that reviews all of them, not just one person providing a report, but each of the board members reviewing reconciled bank statements. It's very, very difficult. And in fact, about as good as the fraud gets or the embezzlement gets is maybe a 30-day or a 20-day head start because the review cycle. But having board members look at reconciled bank statements, very, very difficult to do a sustained fraud or embezzlement. All right, question: which insurance companies are best for HOAs and the coverages you mentioned? Property board protection. I'm going to sidestep that one, and I'll answer it this way. I can't recommend any insurance company. There are well-known insurance companies that issue what I've heard are really good policies. So you'll just need to do a little investigation. I have found that there are a number of out-of-state companies that specialize in community associations, and so it would be worthwhile Googling community association insurance company and exploring those. Talking to a local insurance broker, someone who places a multitude of different companies is a good idea as well. And then finding out. So this works well for covenant amendment, enforcement techniques, also insurance. Find a neighborhood that you like, that you think is well run, that's pretty, and try to determine what insurance they have, and just network with some of your other association board members in other neighborhoods and see what information they have. I'm sorry to ditch the question. That's just as good as I can get you. But there are really good companies out there that you can find. Patrick.
Oh, I just wanted to mention too on the insurance topic, from a bank perspective, we recommend Fidelity Insurance for the board. So that basically means if you have a bank balance or loan you money, and that Fidelity Insurance should equal the amount you have in your reserve and operating. So what that does is covers any fraud or embezzlement and things like that of someone taking those funds and going to Jamaica, for example.
Yes. So investigate those different coverages, and and the board exercise its discretion on how much, what kind of I'm drawing a blank on. It's not premium, deductible. Good grief. So the board exercises its discretion on the amount of deductible and ask the question, okay, if our policy has a $20,000 deductible, do we have that money sitting around, or do we need to have that money in a reserve or a bank account ready to pay that so that we have access to our insurance? Okay, so we're at 8 o'clock. I covered most of what I wanted to cover. There's a couple more slides that are somewhat self-explanatory, but thank you guys for hanging in there 2 nights out of a week for 2 hours. I know this is a long slog, but it's a lot of information, and hopefully you got at least a little bit of something out of it. And thank you, Patrick, for being with us. And thank you, Georgia Neighborhood Alliance, for hosting this again.
Thank you, Matthew. Thanks again, Patrick. And thank you to every one of you. Whether your neighborhoods know it or not, they're very, very lucky to have all of you that are willing to sit in here and learn this information and pass it on. Call on Neighborhood Alliance if you need us. Now, don't call us from this coming Friday until January 10th because we are on our holiday sabbatical. We take 3 weeks off. The entire staff gets to go home, relax, spend with their families, spend the holidays, and then come back refreshed to be able to provide lots of services for you. But come January, we'll be back. We have lots of workshops scheduled for the Norman. We will also be sending you can sign up for our emails on our website, and you're always welcome to join any of the workshops that we do for Oklahoma City as well. The information, the state laws are always the same. Sometimes there's a little bit of ordinance difference between Norman and the city, but as far as practices go, it's the same. So we're lucky to have you. We're proud to be in Norman, and thank you all very, very much for coming. Have a wonderful holiday. Thanks, Sarah, for helping. Bye-bye.
Thank you all so much.
Thank you, guys.
Thanks.